The Honourable Michael Woodhouse.
Thank you, Mr. Chairman. I'm a little disappointed, actually. I did think there might have been some opportunity to just not convince, but encourage opposition members to understand that when they say they want to support exploited migrant workers, they need to have a greater value on the protection and prevention of exploitation than they do on the protection of people who are unlawful. Because effectively what we're hearing today is that Labor and the Greens want to protect migrant workers, but not as much as they want to protect people who are unlawfully in this country and who might be subject to a search power that they don't like. That someone liable for deportation can sit there laughing at an immigration officer with passport on the table and say, that's okay, because that's consistent with some human right that they have to fly in the face of common sense. Well, I'm really sorry. I cannot, for the life of me, fathom how when many times during the last 6.5 years, the Labor opposition has said, we don't think it goes far enough, fast enough, but we'll support it anyway because it doesn't do any harm. They must think the harm that this bill does to people who are unlawfully in New Zealand and may be subject to what they perceive, not the Ministry of Justice, not the Attorney General, but what they perceive to be an illegal search power, is strong enough to prevent them from supporting exploited workers. Clearly they didn't get the memo from the CTU. The CTU support this bill. The CTU are in favour of this bill, notwithstanding their misgivings. Now, I want to touch on the issue, and I cannot understand for the life of me why they're dancing on the head of this technical pin about why power isn't given to Labor inspectors. Well, I suggest to the members that there is a very good reason why I'm both Minister of Immigration and Minister for Workplace Relations and Safety. Such is the symbiosis and the overlap between those two important functions of public sector. That is the maintenance of minimum employment standards and the protection of all workers, lawful, unlawful, whatever their industry, wherever they are. And I have been encouraging and cajoling and imploring, and I've been very pleased with the response, but those two areas, Labor Inspectorate and Immigration Compliance and Fraud, to work more closely together, more seamlessly. We've significantly boosted resources in straitened times to enable them to do their jobs better, but we've asked them to work smarter. And they are doing that, and they're doing that much more effectively. The flow of information between the Labor Inspectorate and Immigration New Zealand is preventing and prosecuting far more illegal activities than ever. Now, I'm sorry that the volumes are going up, and that's why we're improving minimum employment standards at the same time as passing in the Immigration Amendment Bill. And I think it is an indictment on Labor and the Greens that despite whatever misgivings they have, they cannot bring themselves to support this bill when their track record of pragmatic support for other legislation, even though they don't think it's gone far enough or fast enough, speaks volumes. Speaks volumes to how bitter they must feel right now. Because this is the one bill where I thought, despite those misgivings, we would have that support. And I am deeply disappointed, but always the optimist. It's not too late. It's not too late for them to have a change of heart. I want to acknowledge Clayton Mitchell's intervention. He had the same concerns, but true to form, New Zealand First, they just want to close the borders. That's their solution to migrant exploitation. Let's not have migrants. Well, that'll be a great sell for the champions of small business in Northland. They can go up there and say when they want to grow their primary sector, when they want to grow those industries ahead of the demand for labour, don't worry, no solution there. But I will accept this, and I will accept what Mr Twyford and Ms Moroney said. Successive governments of all colours have always had a Kiwis first approach to immigration policy. And I will accept, I'll come to Queenstown, because those champions of small business are going to go down to Queenstown and say, forget that stuff that National's done. Labor in office, they wouldn't do that. They wouldn't support small business in Queenstown because it is different down there. And I do accept, here is the point, Mr Chairman.
I will call the Minister again, but I am going to issue the same warning to him as I issued to members before. We are now talking about the detail of the bill, not broader immigration policy.
Thank you, Mr Chairman. I will accept, I'll finish on this point. There are a number of industries who have relied, and areas who have relied far too much on immigration policy to inoculate business risk, and it is important that immigration policy is at the end of a pipeline that has other strategies to improve the domestic availability and supply of labour to meet those growing job demands. I think we all have that in common, but in the Canterbury rebuild, in places like Queenstown, in our horticulture industry, it will always be necessary at this time to rely on immigration policy to meet those labour needs, and the challenge of this House is to make sure that those temporary labour market tested temporary visa holders are protected. Now, I want to touch on an issue that Ms Logie raised in the second reading, because it actually goes to the heart of some of the themes of what's coming through here in terms of why are we doing what we're doing, and it relates to the issue of a power that will be given to the Minister of Immigration to consider the liability for deportation for people who have lied on their visa applications. And she said that this was somehow going to catch people who inadvertently make a mistake on their visa applications or didn't understand the questions. Well, that's not true. That's not what the bill says. But I was flabbergasted. And she also said that the Select Committee never considered this. There is no problem to solve. Well, that is also not true, because the Select Committee were advised by officials the grounds that required this particular change. And that was a widespread rort uncovered some years ago on police vet checks for labour market tested visas and residence applications under a certain category, where hundreds of applicants had been given false police clearance letters. Now, it doesn't matter who, it doesn't matter where. But when I was asked when I would see these files for consideration of deportation, I was said if the applicant, notwithstanding that they had lied on their application, would have otherwise been granted a waiver, a character waiver, and given residence, there are no grounds for me to reconsider that decision. And I think that's ludicrous. And that's why I've proposed the amendment. It means that a commission of a criminal fraud on a visa application could be grounds for deportation. And the Greens won't support this bill because that's somehow unfair to a person who has committed a criminal fraud. And they see that as more important than the protection of legally entitled workers in this country from heinous exploitation. And I find that a damn shame, because it speaks volumes for the parties that are not supporting this bill. I encourage them to reconsider. I encourage them to see that whatever misgivings they have about those clauses in respect of search powers and a power to deport for a criminal fraud, that they set aside those misgivings. They don't even put an SOP in. Mr Twyford goes on about the Labour Inspectorate not having the powers. Where's the SOP? We can't even consider it because they won't put it up. And I think that's a bit lazy. But it isn't too late for Labour to have a second thought, a reflection on whether or not they really are the party of the people and the champion of the workers and not the fraudsters, and support this bill. There is still time.
Mr. Chairman.